Issues around economically weaker section EWS quota. Recently, the Attorney General of India articulated that the 10% quota for economically weaker sections EWS of society does not erode the rights of the scheduled castes, the scheduled tribes, or the other backward classes. Nurses. Key points: does not harm quota of other classes. The EWS quota was given independently of the already existing 50% reservation granted for the backward classes, that is, the scheduled communities and the OBCs. The Attorney General rejected arguments by petitioners that the exclusion of backward classes from the EWS quota amounted to discrimination, as they have been located with benefits by way of affirmative actions. For example, the members of the scheduled caste and scheduled tribe communities have been given several benefits under the Constitution, including Article 16(4)(a), special provision for promotion, Article 243(d), reservation in Panchayat and municipality seats, Article 330, reservation in the Lok Sabha, and Article 332, reservation in the state legislative assemblies. According to necessary to uplift the weaker section, the reservation of the backward classes and now the EWS quota should be considered by the court as one single approach of the state intended for the upliftment of the weaker section of the society. Altogether, 18.2% of the total population in the general category belonged to EWS and referred to the multidimensional poverty index used by the Niti Aayog, which would be about 350 million, 3.5 crores of the population. Confer the Constitution. The reservation for OBCs, SCs and STs fall under different folios other than the EWS quota, and it does not violate the basic structure of the Constitution. Example: the government referred to how the top court had stood by the validity of the right of children to free and compulsory education Act 2009. The court had held that the 2009 Act seeks to remove all barriers, including financial and psychological barriers, which a child belonging to the weaker section and disadvantaged group has to face while seeking admission, and therefore upheld it under Article 21 of the Constitution. Counter-arguments. The amendments run contrary to the constitutional scheme, where no segment of the available seats posts can be observed only on the basis of economic criteria. The amendments also run contrary to the judgment pronounced in the Indira Swahni vs. Union of India 1992 case that a backward class cannot be determined only and exclusively with reference to economic criteria. The amendments alter the 50% quota limit set up in Indira Swahni vs. Union of India 1992 case, which according to the petitioner is a part basic structure of the weaker section.